You are now listening to the Vegan Stuff podcast with Caavakushi.
Hosting this podcast today are our two AI hosts, Sam and Kim. If you simply can't get enough of us, go to caavakushi.com and sign up for our vegan newsletter and get our free 7-day high-protein vegan meal plan. And we also have some good news. We will be releasing our first ever cookbook pretty soon, so stay tuned. Hey, don't forget to follow us on our socials too.
Welcome back to the Deep Dive. Today we're immersing ourselves in a really high-stakes, globally resonant conflict. It's unfolding in one of the most critical ecosystems on the planet, the Maasai Mara in Kenya.
It's a phenomenal area. Everyone knows it for the Great Migration, of course.
Of course.
But this story isn't just about the wildlife. It's really about the clash between, immense luxury development, local land stewardship, and these very aggressive conservation efforts.
Okay, so our task today, our deep dive mission, is to get into the details here.
Exactly. We're going to dissect the court documents, the environmental reports, and all the legal maneuvers surrounding the proposed Ritz-Carlton Maasai Mara safari camp.
So we're essentially looking at the intense pressure that this kind of high-end global ecotourism puts on fragile environments.
Right, and the legal battles that erupt when those pressures just become too great.
And we have sources that detail everything from, concrete construction on vital migration paths all the way to the pretty astonishing use of a judicial gag order against a prominent community leader.
Yeah, our mission here is to clarify this really messy legal and environmental landscape. We want to understand not just the allegations, but the corporate defense, the government's justifications, and, what this specific case reveals about the future of African conservation.
Okay, let's unpack this. Let's start with the core allegations that kick this whole thing off. The opposition sounds really organized and fierce.
It is, and it's driven primarily by local Maasai leaders. The lawsuit was brought forward by a group of community leaders, and the main voice is an elder named Maidame Olo Dapash.
And their claim is what, fundamentally?
It's simple, but it's existential. They're saying the new hotel development, which is being constructed by a company called Lasizi Mara Limited.
Okay, under the Marriott franchise.
Exactly. They claim it poses a direct and immediate threat to the fundamental mechanics of the Maasai Mara ecosystem.
I think we need to be very specific here, because the threat isn't just, an eyesore. It's locational and it's structural.
That's the critical point.
So where is this PAM, and why does that specific location trigger such alarm?
It sits directly along the Sand River. And the Sand River is not just any body of water. It's a non-negotiable, essential artery for the Great Migration.
Right.
So the lawsuit alleges that this development is obstructing a crucial migration corridor. We're talking about hundreds of thousands of wildebeest, zebra, other animals. They use this path to move north or south, especially when they need water and fresh grazing.
So it's a bottleneck.
It's a major bottleneck. If you disrupt movement here, you disrupt the entire migration itself.
And that brings us to the actual construction,
Yeah.
which really paints a vivid picture of the potential harm. What exactly did the developer build that is causing such a specific block?
According to the lawsuit, the construction included building concrete embankments.
Oh.
Yes, directly into and along the riverbank. And this is where the opposition really focuses its environmental damage claim. They argue these concrete structures literally prevent animals that are exhausted, desperate for resources, from reaching vital grazing areas and drinking access along the river.
It's an engineered barrier.
It's an engineered barrier to life-sustaining resources. Yeah.
That detail is just chilling. You have this image of thousands of animals hitting a concrete wall that was built for a high-end tourist facility.
And it connects directly to the sources showing how stressed this ecosystem already is.
How stressed are we talking?
The sources remind us that the Maasai Mara is already under immense ecological pressure. The wildlife population in the reserve has fallen to less than a third of what it was in the 1970s.
A third. That's catastrophic.
It is. So when you have an ecosystem already dealing with decades of pressure from poaching, climate change, habitat fragmentation, any new high-impact construction along a crucial path like this is seen by conservationists as, well, potentially the straw that breaks the camel's back.
And it also makes you question the whole term ecotourism, especially when you look at the price point for this place.
Precisely. Critics are highlighting the massive luxury component. We're talking about rooms that can go for upward of $3,500 per person per night during peak season.
Wow.
And they argue that this kind of ultra high value, resource intensive development, it just symbolizes a focus on extreme profit rather than genuine ecological stewardship. It undermines the very idea of sustainable tourism in the Mara.
Did you know we have a vegan search engine, a vegan forum, a vegan newsletter, and so much more coming soon? So why not check us out at Caavakushi.com.
Here's where it gets really interesting, because that is a powerful set of allegations. But the corporate side of this, Lasisi Mara and Marriott, they have a strong defense that's backed up by official documents. What's their position?
Their defense is rooted entirely in procedural compliance. Lasisi Mara and Marriott maintain that the hotel was built in full accordance with all necessary Kenyan regulations, permissions, and permits.
So they're saying, we followed the rules.
We followed the process set out by the Kenyan state. Exactly.
And the centerpiece of this defense is the Environmental Impact Assessment, the EIA. For anyone listening who's unfamiliar, what's the procedural weight of an EIA in a case like this?
The EIA is supposed to be the foundational document. It's meant to be a thorough review conducted by official Kenyan authorities to assess the project's environmental consequences before construction begins.
Okay.
And Lasisi Mara's defense hinges on the fact that an official EIA was conducted. And crucially, this assessment came to a conclusion that directly contradicts the conservationists' main claim.
Which is?
The EIA determined that the specific site was not a wildlife crossing point.
So that creates a fundamental factual deadlock. The local leaders see a daily crossing point being blocked by concrete, but the official government document says, our assessment shows this site is benign.
Exactly. But the lawsuit doesn't just stop at disagreeing with the EIA's conclusion. It attacks the validity of the whole process.
How so?
This is where it gets procedurally complex.
Right.
The lawsuit claims that there is no public record of the required EIA, which immediately raises a huge question about transparency. If this official assessment exists and it concluded the site was safe, why hasn't that documentation been made publicly available for people to scrutinize? The lack of a public record just feeds the perception that the assessment might have been, compromised or rushed.
And if the official record is missing, or at least being withheld, that severely weakens the corporation's defense of compliance.
It absolutely does, especially when you factor in the other major procedural violation the plaintiffs allege.
There's another one.
Yes. The project allegedly violates an existing critical local policy, the 2023 Narok County Management Plan.
Tell us about that plan. What did it mandate?
The 2023 plan enacted a moratorium, a complete ban on all new tourism developments in that specific area of the Maasai Mara until 2032.
A ban until 2032.
Yes, and this moratorium was put in place for a reason. It was because of ongoing degradation and stress on the ecosystem that earlier studies had revealed. It was a formal acknowledgement by the county that they needed to hit pause on development to give the Mara time to recover.
So the conservationists are arguing. You built a massive luxury hotel on a critical path. You allegedly don't have a public record of your environmental review, and you did it despite a clear county ban on all new developments.
That's a powerful trifecta of legal challenges, yes.
It is. It forces us to ask, how did this development move forward at all if this binding policy was in place?
And that brings us back to the role of the local government.
Right, the political component, which so often determines the outcome. How did the county justify bypassing its own 2032 ban?
The county granted a formal exemption from the moratorium for the Ritz-Carlton development.
An exemption. And the justification was?
The primary justification, which is officially cited in our sources, was the need to attract high-profile foreign investors. They essentially weighed the need for strict environmental regulation against the immediate need for revenue and jobs.
And they packaged this politically as a move toward high-value tourism, is that right?
Yes. County officials defended the decision by arguing that focusing on a few extremely high-end luxury brands like Marriott could generate more revenue with less overall physical impact than, say, allowing dozens of smaller, less regulated camps to pop up.
A strategic choice, they claimed.
They claimed it was a strategic choice to maximize profits while minimizing sprawl.
That argument seems compelling on paper. Fewer structures, more money. But what's the counterpoint from the critics?
Well, critics argue that this justification just masks the prioritization of immediate profit and investment over long-term ecological health.
Right.
They point out that a single massive luxury operation, even if it's high value, requires tremendous infrastructure, water, waste, personnel, that small local camps just don't demand. In their view, the exemption wasn't about conservation strategy, it was about political expediency. It was about prioritizing a single lucrative deal.
And this need to protect that high-value investment, that leads us directly to the most controversial element of this entire legal dispute.
The gag order.
The gag order.
This is a significant escalation of the conflict. In November of 2025, a Kenyan court issued a gag order specifically targeting Maasai Olol Dapash, the Maasai elder and lead plaintiff.
A gag order is a very serious legal tool. It essentially silences someone from public discussion of a pending case, who requested it, and what was the official argument they used in court.
The order was requested by Marriott's legal team, and their argument was, well, it was remarkable. They claimed that Dapash's ongoing, highly effective public campaign against the hotel,
which included speaking to international media, organizing local opposition.
All of that. They argued it was too influential, that his advocacy was unduly influencing public opinion and potentially prejudicing the case.
So the argument wasn't that he was lying or revealing classified information. It was that his voice was simply too powerful.
Exactly. And the court agreed and issued the order. It legally restricts Dapash from speaking publicly about the legal case, the alleged environmental violations, anything about the status of the development.
That feels like a fundamental shift to the battlefield.
It is. It went from a debate over conservation policy and procedural compliance to a restriction on a community leader's basic right to public advocacy.
So what has the response been to this gag order? Because legally restricting the public speech of the lead local voice in a debate like this seems to cut to the very heart of the matter.
The criticism has been intense and widespread. It's widely seen not as a necessary protective measure for the court process, but as an aggressive corporate legal strategy designed to silence the most effective opponent.
So instead of addressing the issues.
Exactly. Critics argue that instead of engaging with the fundamental conservation issues raised in the lawsuit, the blocked migration path, the missing EIA, the company chose to use the legal system to eliminate the voice of the person raising the loudest alarms. It effectively curtails the ability of the local community to advocate for their ancestral lands in the public arena.
And this whole complex web of claims and defenses, it's all culminating very soon, right?
Yes, the primary court hearing on the fundamental matter, the validity of the permits, the environmental claims, all of it, is scheduled for December 2025. It's going to be a landmark case for the future of conservation law in Kenya.
This has been a true deep dive. Let's try to synthesize the key friction points we've covered for you, the listener. We started with the intense conservation claims that the Ritz-Carlton camp is blocking the critical Sand River migration path with concrete embankments.
Right, threatening the very mechanism of the Great Migration.
Then we looked at the procedural disputes. The corporation argues compliance. They cite an official EIA, but the plaintiffs counter that the required paperwork isn't publicly available,
which raises major questions of transparency. And this all happened despite a clear 2032 moratorium on new development. An exemption was made, justified by officials who prioritized attracting investment through high-value tourism.
And finally, we discussed the alarming use of a gag order against the lead Maasai elder, Maasai Olol Dapash, requested by the hotel's lawyers because they found his public advocacy to be too influential.
It summarizes a collision between global capital and local ecological stewardship, all mediated by government policy and these aggressive legal tactics.
What's fascinating here is how the dispute it perfectly encapsulates the global challenge that so many developing nations face.
It really does. How do you protect a globally significant natural heritage site while you simultaneously need to generate revenue and satisfy high-profile investors? This case forces a hard look at whether procedural compliance and official government documents are truly sufficient safeguards against determined high-value development.
It certainly does. And here's a final provocative thought for you to consider, something to mull over as you reflect on this case. When critical conservation issues that affect an entire ecosystem are being debated in court, and those issues rely on transparency and public accountability, what does it mean for the future of environmental advocacy when the legal process itself can be used to silence community leaders who are deemed too influential in the public square?
Does the restriction on public speech essentially render the courtroom the only place where these critical issues can be heard?
away from the scrutiny of the local people who are most impacted.
An essential question to ponder.
Thanks for diving deep with us. We'll be watching this case closely.
Thanks for listening. We hope you liked this episode. If you did, we'd really appreciate it if you could give us 5 stars on whatever platform you're listening to this podcast on. Also, we would be so appreciative if you could just share this episode or this podcast with all your friends and family who are vegans or vegan friendly. We're also really excited because we are going to be launching something really cool pretty soon on the site, so keep an eye out for that. And we will see you really soon with a new episode.